All right, good morning. Today's date is October the 6th, 2025, the morning docket of Lawrence County Municipal Court. First group of cases we're going to call a review hearing, so when you hear your name called, come down to the table on my left, your right, and we will go through your case.
Jamie Baker, William Baker, Christopher Casella, Christopher Collins, Jeffrey Collins, Naaman Cox, Christopher Dawson, Gary Kazoo.
This is the State of Ohio versus Jamie Baker, 25402. Looks like you made a $100 payment in September. You're down to $200 left on the case. You have a payment today?
Not sure.
You're not sure if you have a payment today?
Well, I'm on fixed income.
Okay.
I could try.
Well, you can work it off on community service if you wish.
Yeah, when?
Well, if you'll show up on this coming Saturday, we do community service every day except Sunday, but if you show up this Saturday, it's a double credit day. And so you can knock $100 off by coming and working Saturday.
What time?
7:30 a.m. here at the courthouse. All right, let's set you an overview date. November 17th. Review at 9 a.m.
17th, 9 a.m.?
17th at 9 a.m. If you've got it paid off or you've got it worked off, then you don't have to come back. Your case will be closed.
All right.
Okay?
Am I dismissed?
You're dismissed.
Y'all have a beautiful day.
Thank you, you too. William Baker, State of Ohio versus William Baker, CRB 24332. Looks like you've done 12 hours of community service since you were last here. You're down to 18 hours. Looks like the fine's all paid. So likewise, if you can knock out 12 of those hours and come next Saturday.
Try to take advantage of that, sir.
Very good report as well. We'll set you back as well for November 17th. For review 9 a.m.
Thank you, sir.
Thank you. Christopher Casella.
Yes, sir.
All right, this is State of Ohio versus Christopher Casella, PRC 24-2500. All right, you've worked off a substantial amount of your fine.
Yeah, I got that 3-day schooling thing I got to do. I got it paid for. Michelle from a recovery place was supposed to call fax or something, John in there, where I paid it and everything, and I got to do that the 16th of this month.
Okay, great.
And I think I'm done besides the fine. I've been working 2 jobs, and I'm going to try to start paying coming in on Saturday and stuff and finishing paying the fines off, but I do go the 16th of this month.
Well, if you can make it this coming Saturday, you can knock $100 off.
Okay.
I mean, I always advise everybody, if you get a double credit day, take advantage of it.
Okay.
2 for 1. So.
Yeah, I've been working 7 days a week between both jobs, and but I finally got that class paid for, so I think that's the last thing I had to actually do is just the class, but I got to be down there the 16th.
All right. Well, I'm going to set you back on November 17th. That should be the following day after your class. Or no, well, I guess you're doing it this month, aren't you?
Yes, yeah, October
Okay.
16th, yeah.
All right, so it's going to be November 17th
Okay,
for review at 9 a.m.
okay. So after I get the schooling done, I think I'll have to actually left the fine then?
Yep, once the fine is taken care of, then case will be over.
Awesome. You say November
17th,
17th,
9 a.m.
9 a.m.?
Yes.
Okay, thank you.
Christopher Collins. This is the State of Ohio versus Christopher L. Collins, PNC 24-1976, A, B, and C, CRB 24-613, A, and B.
Thank you.
I don't see any activity since August 25th that you've you done anything?
Yeah, I just got paid on the fines.
Okay.
I'm gonna come in Saturday. I didn't know it was double day again.
Well, since you haven't done anything on here, I'm going to order you to be here Saturday.
Oh, I'll be here. I did the last double thing too.
All right, I'm going to give you an opportunity to do that.
It just, this past month here has just been kind of hard. I've had cheerleading competitions and football games and all that with the kids and all that, you know. But I ain't making no excuses up. I mean, before football season, I was trying to make it regular, you know.
All right, well, we'll see you back November 17th. I'm ordering you to be here on October the 8th at 7:30 a.m. for the double day community
You
service.
say November 17th?
Yes, sir.
All right.
What is it?
What is the land?
Oh, yeah, sorry. I'm on November still on the calendar.
Oh, yeah, that's my
So
birthday.
October 11th is when you're...
That'll be on Windsor, wouldn't it?
This Saturday,
Yeah,
this
that-
coming Saturday.
But I mean, that'll be the Windsor cleanup?
Yes.
Okay.
All right.
All right, thank you.
Jeffrey Collins.
He's on the telephone.
Yes, sir.
This is State of Ohio versus Jeffrey S. Collins, PRD 24-15-21, PRD 19-1082, PRD 19, or excuse me, CRA 19-304. All right, Mr. Collins, I saw you made a web payment last night.
Yes, sir.
You still got a pretty good ways to go on these cases, but you're making progress. So,
I'll try to get a double day too, because that would help knock it down some, so
well,
I'll get that off.
all right, take advantage of that. I'm gonna set you back November 17th for review at 9 a.m.
Thank you,
All right, thank you. Neiman Cox?
Sorry, I
All right, State of Ohio versus Neiman Cox, CRB 23-569, PRC 22-1663, ABDC E, PRC 21-3062, A, B, and C. All right, Mr. Cox, are you still in treatment?
No, I've completed all of that. This is just a really ongoing thing because I stacked up a lot of stuff all pretty close together. It's just ongoing reviews.
Looks like you've gotten a bunch of community service done.
I actually completed some more, but I do not have proof of it with me today. I talked to Major about it. He told me to inform you about that he did take note of it, but I do not have proof of it yet.
Got it. All right, well, you've done a substantial amount there. You're making good progress. So I'm gonna set you back for November 17th for review at 9 a.m.
Is that all?
That's all.
Thank you. Have a great day.
You too. Sir, what's your name?
Christopher Dawson.
All right, this is State of Ohio versus Christopher Dawson, PRC 24-21-38, A, B, C, D, and E. All right, looks like you're just down to your...
I also have that scheduled for the 16th as well.
Okay.
Yeah.
Well, here's what I'll do then. I'm gonna set you back for November 17th. Make sure you have proof of that at that time. If after
I have a
you-
receipt.
That's okay. Oh, I gotta see that you completed it.
Oh, okay.
So the completion certificate. But once you have done that, if you'll stop by and drop the certificate off to Mr. Major and Mr. Cooper,
Mm-hmm.
we may be able to go ahead and close your case out. You don't have to come back on the 17th.
All right.
Because there's nothing left for you to do other than to complete that skill. So as soon as that's done, your case will be completed.
Yes, sir.
All right. So I'll put it on for November 17th in case something happens, but bring that proof in and we'll get it taken off.
Yes, sir. Thank you.
Thank you. Gary Cassey?
Yes, sir.
All right. See, you also made a web payment.
Yes, sir.
All right, looks like this is State of Ohio's Gary Cassey, CRB 14309, CRB 16166. On the 14309, you're down to $840 left. And you're down to $366 on the 16166. I mean, these are some pretty old cases, Mr. Kazee.
Yeah, I've actually paid a lot.
You have. I'm gonna give you the same opportunity. If you come work community service next Saturday, you can knock off $100.
I kinda have a lot going on, so I'll just go ahead and continue to pay.
Okay.
Honestly.
All right, I'll set you back for November 17th
Okay.
for review at 9 a.m.
All right, thank you, sir.
Thank you.
We're ready for arraignment, Your Honor.
All right, next group of cases we're going to call are arraignments. So when you hear your name called, come down to the table on your right, and we'll go through the charge or charges with you. You'll have the opportunity to enter a plea on misdemeanor cases, if you're here on misdemeanor, and you can enter one of three pleas: guilty, not guilty, or no contest. Guilty plea means you're making a complete admission you committed the offense charged. A not guilty plea means you are denying that you committed the offense charged. And a no contest plea means you're not admitting that you committed the offense charged, but you're not contesting the facts surrounding the offense either. And if I think there'd be enough evidence to convict you, I can enter a guilty plea or a guilty finding in the case. You have the following rights before the court. You have the right to remain silent. We're recording everything in here today. A lot of people decide they want to tell me things about what went on. Sometimes that might be in your best interest, sometimes it might not be. If you say something that is not in your interest, it's being recorded. The representative for the state of Ohio is listening in the back, and if he hears that, he can then use it against you at a trial, if it goes to trial. You have the right to have reasonable bail. You have the right to have an attorney. If you can't afford an attorney, I can appoint one to represent you at the state's expense. And you have the right to force the state to prove each and every element of the offense charged beyond a reasonable doubt. You would go ahead and call. If you're unsure of what you should do, then you should enter a not guilty plea because it preserves all of your rights before the court.
State of Ohio versus Daniel Brinzer, case number TRC 252528.
This is State of Ohio versus Daniel J. Brinzer, TRC 2528. Sir, Mr. Brinzer?
Yes, sir.
All right. Mr. Brinzer, it's alleged that on or about October 1st, 2025, in Fayette Township, that you were operating a motor vehicle while under the influence of alcohol or drug abuse or a combination thereof. That's an alleged violation of Ohio Revised Code 4511-19A1A. That is a first-degree misdemeanor. It's also alleged that you had a prior well, we don't need to get into that. It's outside the look-back period. That's a first-degree misdemeanor. The maximum penalty you can face is up to 180 days in jail, a $1,375 fine, a 3-year license suspension. The minimum penalty that you can face on this would be 3 days in jail or 3 days at a driver intervention program, a $575 fine, and a 1-year license suspension. How do you wish to plead?
At this moment, not guilty.
Okay, I'll accept your not guilty plea. Are you, do you have money to hire your own attorney?
Possibly. If not, I might have to get a court-appointed attorney.
Well, let me ask you this. Are you working currently?
Yes, sir.
And are you paid hourly?
Yes.
How much do you make per hour?
$21.
And are you working full-time,
Yes.
40 hours a week?
40 hours a week.
Do you have any dependents?
No.
Okay. Well, you're not going to qualify for appointed counsel, so you have to hire your own. You make too much under the guidelines. I'll give you time to do that. I'll let you sign a $1,000 OR bond. And I'll set your next hearing. I want to give, how long do you think you'll need to hire an attorney?
At least a month.
I will set your next hearing then for November the 7th. He will need to get fingerprinted if he wasn't taken to jail. So I'll also order you to appear at the jail for fingerprinting.
Sign right there, that's for your signature, Mark. And don't leave, wait on me, I'll go up and I'll bring you a copy of that. Okay.
All right, so November 7th, 2025 at 10 a.m. will be your next pretrial.
Okay.
If you hire an attorney and they need to move that, that's something that they can do. Just make sure you stay in touch with your attorney. If you haven't hired an attorney, you need to appear that day.
Okay.
Okay?
Thank you.
Thank you.
State of Ohio versus Hudson Batten, case number TRC 252540, A, B, C, and D.
This is State of Ohio versus Hudson Batten, TRC 252540, A, B, C, A, and D. Mr. Batten, it's alleged on or about October 4th, 2025, in Union Township, that you were operating a motor vehicle while under the influence of alcohol, or drug abuse, or combination thereof. That's an alleged violation of Ohio Revised Code 4511-19A1. That is a first-degree misdemeanor. Maximum penalty on that is up to 6 months in jail, up to a $1,375 fine, and a 3-year license suspension. The minimum penalty on that is 3 days in jail or 3 days in a driver intervention program, a $575 fine, and a possible 1-year license suspension. In the B case, it's alleged that you were operating the motor vehicle on the same day, the same township. You were operating a motor vehicle while without a valid driver's license. That's an alleged violation of Ohio Revised Code 4510.12. That's a minor misdemeanor, maximum penalties up to $150 fine and court costs. It's also alleged that in the C case, same date, same township, you were operating a motor vehicle failed to wear a safety belt. That's an alleged violation of Ohio Revised Code 4513.263B1. That's a statutory $30 fine and possible court costs. It's a minor misdemeanor. And that you were operating the motor vehicle on expired tags on the same date, same township. That being an alleged violation of Ohio Revised Code 4503.11, minor misdemeanor, maximum penalties up to $150 fine and court costs. How do you wish to plead?
Guilty.
All right, so you're making a complete admission that you committed the offenses charged.
Yeah.
Is there anything you want to tell me about this?
I just purchased the vehicle. I haven't been able to get it really changed into my name or nothing just yet, so the whole expired tag thing, I didn't really realize it, but that's about it, really.
All right. On the A case, it will be 10 days in jail. I'll suspend 10 on the condition that you go to the 3-day driver intervention program. It'll be a $700 fine. I'll order you to pay the court costs. $30 hours of community service. The 1 year level 4 probation. disposition, we need to change it to 20 to 10 on that. All right, you'll have a review date on this, April 13th, 2026. On the B case, it'll be a $50 fine and court cost, or no court cost, we're going to do one court cost. So it'll be a $50 fine in this case. On the C case, it'll be a $30 fine. And on the D case, a $50 fine. Be a review on all cases on April 13th, and you'll need to seek probation before you go. And it'll be a 1-year license suspension. All right, you'll need to seek probation before you go, and it should be out to the left.
Okay.
All right, thank you.
Have a good day.
State of Ohio versus Christopher Rhodes, case number TRD 20-2138.
All right, this is State of Ohio versus Christopher Rhodes, TRD 20-2138. It's like alleged that on or about December 7th, 2020, that a capias was issued for Mr. Rhodes for failing to appear for an arraignment on this matter. Mr. Rhodes, do you admit or deny that you failed to appear for your arraignment?
No, I admit, that's correct.
Okay. Do you have a good reason as to why you did not appear?
Honestly, just kind of forgot about it. Life-changing events. I lost my job, so I wound up moving with my mom to South Carolina. Long story short, I applied for the railroad, and they did a background check, and this is what came up.
That came up?
Yes.
All right, so we'll go ahead and I'll recall the capias. We'll go ahead and do the arraignment on this. It's Mr. Rhodes, on or about October 15th, 2020, in Fayette Township, it's alleged you were operating a motor vehicle without a valid driver's license. That's an alleged violation of Ohio Revised Code 4510.12. It's a minor misdemeanor, maximum penalty is up to $150 fine and court costs. How do you wish to plead?
Guilty.
All right, I'll accept your guilty plea and enter a guilty finding. It'll be I'm going to give you just a slightly higher fine.
I understand.
Since this was a 2020
Yep.
case, it'll be a $50 fine and court costs.
Okay, that's fine.
Can you take care of that today?
Yes, sir.
All right. Take care of it today. I'm going to go ahead and set a review on it for April 13th of 2026 at 9 a.m. If you pay it today, it'll cancel that out and you don't have to be here.
Okay.
Just in case somehow something happens that doesn't get paid, we set it for a review.
To do it right now. But one more question. So, will they give me a copy of that?
Yes, once it comes out, you'll get a copy of it when you go and pay. And
Okay.
there's your receipt showing that it's paid and that it's taken care of.
And the warrants part, all that would be,
Yeah.
okay, I just have to email them that way. Okay, thank you.
All right, thank you.
Your Honor, what was the fine amount again?
$50.
State of Ohio versus Rafael Zavala, case number TRC 252507. Rafael Zavala.
This is State of Ohio versus Rafael Zavala, TRC 25-2507, A, B, and C. Time is now 10:18 a.m. Rafael Zavala. Mr. Zavala has failed to appear. Will be a capious issue.
Your Honor, we're ready to start some pre-trials. We have some more arraignments coming, but we're not ready for those yet.
All right. If you have a pretrial, come in the courtroom. Need attorneys in the courtroom as well.
State of Ohio versus Connor Abrams, case number TRC 25-2107, A, B, and C. Mr. Delato's case.
This is State of Ohio versus Connor Abrams, TRC 25-2107, A, B, and C. Mr. Berlotto's case set up at pretrial.
Yeah, this one. Just that. No, and then another one. It was Daniel.
Judge, I think we have this resolved. I haven't had a chance to talk to him and his mother yet. Could we call this up just a little later in the document?
State of Ohio versus Craig Bowe, case number CRB 25-310.
This is State of Ohio versus Craig Bowe, CRB 25-310. Mr. Berlotto's case set for a pretrial.
Judge, I don't think this is able to be resolved. We're going to need a trial date on this.
All right, do you have a proposed trial date you want to look at, Mr. Berlotto?
Do you care, Craig?
I think we moved a bunch of training ahead.
When is it?
Yeah, I think we moved it up, not sure yet.
Can you do it on November 10th?
Should be able to.
How about November 10th? Do you have room?
November 10th would be fine. How's that work for the state?
The only thing could possibly cause a problem is if we don't have all of our witnesses. We have 2 deputies, so we might have to ask to move it if it turns out that one of them or any of the other witnesses turn out to have a reason why they can't be here.
Okay. Well, I will set it then at this point for November the 10th for trial at noon. And we'll heat up at that point.
Thank you, Your Honor.
Thank you.
State of Ohio versus Madeline Wine, case number TRC 2064, A and B. Madeline Wine.
Judge, she's traveling here from Bowling Green. She got relocated for job. She called this morning and said that her ride, she can't drive because of this charge. Anyway, her ride had a flat tire, and so she made other arrangements. She should be arriving any minute, but if you could call this up later in the docket, we may have this resolved also.
Okay, matters when we pass till later in the document.
State of Ohio versus Christopher Massey, case number TRC 25-1879.
The State of Ohio versus Christopher Massey, PRC 25-1879. So Mr. Delauder's case set as a pretrial.
Judge, this one we do have resolved. Mr. Hill and I had an opportunity to review the video, and we pre-tried this case yesterday. I believe the state's willing to move to amend this charge to a charge of reckless driving. However, as part of the sentence, I believe the state's going to ask that as a part of his probation, he be required to complete the driving school, which he has agreed to do. Also, the ALS would remain in place.
Mr. Hill?
That is correct, Your Honor. We reviewed the evidence very carefully. This started because there was an allegation that Mr. Massey, they said went into a ditch. I don't know if that's accurate or not, but the troopers, there were two of them, and they located him at his residence after he'd already gotten home. And there were some field sobriety tests that were not terrible, but there's some indication maybe he was impaired, but I don't think we have enough to prove beyond a reasonable doubt. So we are willing to do this compromise.
Okay. Well, I think the court typically would want him to do the school prior to the agreement on that. How far out do you think he'll need to?
He's a concrete worker. Well, not yet. He'll get it done in 90 days, I would think. Can you get it done in 90 days? Yeah.
Well, why don't we do this? I'm gonna set it for December 29th.
Oh, shoot. I'm out that week, Judge. Is there any way we could do it on January 5th?
January 5th would be fine. And if Mr. Massey gets the school done and you want to advance it, you're certainly welcome to
Okay. I see, he'd have to be here anyway on that day, wouldn't he? He'll have to pay the fine and the court costs and things. Okay.
Correct. All right, so I'll set this back for January 5th, 2025 at defendant's request, and I would presume there's a time waiver.
Yes.
And the time's been voted to accomplish that.
Thank you.
Thank you.
State of Ohio versus Muhammad Marir, case number TRC 25-1741 A and B, TRC 25-1836 A and B. This is also set as Mr. Delauder's case. Muhammad Marir.
If he's here, Mr. Hill made a proposal on resolving this case. Mr. Maria wanted to discuss that with his significant other, I think his wife. I think he stepped out to do that, so could we call this later in the docket and we may have it resolved?
Okay. We'll recall this matter a little later in the docket.
State of Ohio versus Kendra Brown, case number CRB 25-221. Your Honor, this is Mr. Holt's case.
All right, this is State of Ohio versus Kendra Brown, CRB 25-221. It's Mr. Holt's case, set as a pretrial.
since we've started court.
I think what we need to do, and I don't think I can do any better at this, is just hold the case out another 90 days. If there are any further problems, then dismiss these charges.
Your Honor, if it please the court, we've taken some time to review some evidence and tried to determine whether we could prove the charges beyond a reasonable doubt, or some other things that we looked at as potential charges. We aren't able to get there. However, it's not that we don't believe that any of this stuff happened. It's just a matter of proof beyond a reasonable doubt. I have Ms. Webb here today, who's the alleged victim, and we've discussed the idea that perhaps the best way to resolve this at this time is if there were an additional 90 days of no further problems. And if we achieve that, then we would be willing to dismiss the charges with payment of court costs.
We're in agreement, Your Honor. We would waive time.
Okay, I'll find that time's been waived. How's your calendar look for January 5th, Mr. Hall?
January 5th?
Yes.
Okay. It works.
All right. I'll set this back for January 5th. And Ms. Brown, if there's no further problem between parties at that date, on that date, you pay court costs, the state's going to move to dismiss.
Yes, sir.
All right. Thank you. See you
Thank you, Your Honor.
January 5th.
January 5th, yes. Thank you.
State of Ohio versus Jason Hunt, TRC 25-2044. Jason Hunt.
This is State of Ohio versus Jason Hunt, here's 25-2044, since he holds the case set as a member.
He's also at Riverside in St. Albans. He has completed the Prestera program.
All right, it's a good report, Mr.
That's fine. Are you probably
Your Honor, I believe we reached a resolution here that in exchange for a recommended sentence, I believe it's just one charge, isn't it? Correct.
Yes.
Mr. Hunt would enter a plea of guilty to the OEI charge, and we would recommend that the court apply his completion of the treatment and residential treatment program at Prestera for the DIP school. I think the state's in favor of that.
And what will that
Put it on the screen, I'm not sure.
We weren't aware of that, but Mr. Hunt indicates he's had an issue with it being, there's another Jason Hunt that he has been.
Okay.
Yeah,
So if you want,
Jason A.
yeah, but I'm birthday 8/20/77.
Okay.
Yeah,
All right.
I get confused a lot with that guy.
All right.
Okay.
right, is that correct, Mr. Hunt?
Yes.
You want to enter a guilty plea?
Yes, sir.
All right, I'll accept your guilty plea and enter a guilty finding. All right, it'll be a $500 fine, or you pay the court costs. 20 days jail, I'll suspend all 20 days. I will give you credit for the DIP school, since you did an inpatient treatment program. Your 30 hours of community service, 2 years level 4 probation. Need to remove the DIP on that.
What do you say about that?
2 years. 4 weeks.
Be a 1-year license suspension. After taking back the offense, take the offense.
Okay. I believe he did surrender his license.
Yeah.
I believe I said 2 years level 4 probation, but if I didn't, 2 years level 4 probation. And I'll set your review for March 13th, 2026 at 9 a.m.
It was the March 19th, so we said.
13th.
13th.
March 13th at 9 a.m. Mr. Hunt, you need to seek probation before you go.
Okay.
All right.
Thank you.
Thank you.
Thank you.
State of Ohio versus Shauna Wolf, case number TRC 25-1875, A and B. It's also Mr. Holt's case.
State of Ohio versus Shauna Wolf, TRC 25-1835, A and B. Mr. Holt's case, set as a pre-trial.
My paperwork, my drawing broke. Got a new one. May we approach, Your Honor?
You may.
Oh, let's go talk to that.
Your Honor, I believe we've reached a resolution in this matter. I believe in exchange for a motion from the state to modify the OVI charge to a reckless operation, Ms. Wolf would enter a plea of guilty, and we would ask on the administrative license suspension, we would ask that she be granted driving privileges for medical purposes because she has extensive medical issues and has to drive for those.
For work.
For work, and she has a child that goes to school, and she takes them extracurricular purposes in West Union.
Mr. Gill.
Your Honor, if it please the court, we reviewed the evidence very carefully in this matter, and we believe that some medical issues that Ms. Wolf, and these things were confirmed through medical records that were provided to us, and they probably would have contributed greatly to the field sobriety tests. One of the things that there was no indication of horizontal gaze nystagmus. Of course, that's more prevalent with alcohol, but nonetheless, the rest of the field sobriety tests, I think, were questionable because of her physical limitations. But we have concerns about her driving. She did refuse the test, and so we are going to ask that ALS suspension stay in place for a year, dating back to the date of the stop. We're okay with the driving privileges for limited purposes. We're okay with the reduction to the reckless operation, and we didn't discuss any details of the fine or any other sanctions.
That's correct, Your Honor.
Okay. Ms. Wolf, is that correct?
It's my understanding, yes.
All right. Mr. Hill, what section did you want to amend that to?
The section that has the 4 points. And that one of the section.
It is.
And I don't know which one it is, Your Honor, I'm sorry.
I'll look it up, Your Honor. You might have it memorized.
Okay. 4511.20?
Yep.
All right, I'll allow the amendment on that, and Ms. Wolf, you want to enter a guilty plea?
Yes.
All right, I'll accept your guilty plea and our guilty finding based upon the evidentiary problems and with your medical history having affected this matter. All right, it'll be a $150 fine. I'll order you to pay the court costs on the A case. You're going to have your administrative suspension is going to stay in effect. That has not been, there won't be any court-ordered suspension, but the administrative suspension is going to stay in effect.
I understand.
I'll prepare an entry for that, Your Honor.
It was 1 year.
Your Honor, do I need to prepare an entry for that, or do we have one for the court?
You'll need to prepare an entry on the driving privileges.
Okay, so we need to stay on leave.
Okay. Is there anything on the B case? Okay.
I believe the Mark Lanes we get dismissing.
No, the Mark Lanes, Your Honor.
All right. B case will be not.
Thank you, Your Honor.
Thank you. And ma'am, you'll have a review hearing on that on April 13th. (2026) at 9 a.m.
Thank you, Your Honor.
Thank you. And I will grant those privileges, Mr. Hall, just for the record, once we go back and prepare the entry.
And now, like, B case.
B case is not.
State of Ohio versus Ethan Anderson, case number CRA 24706.
This is State of Ohio versus Ethan R. Anderson, CRA 24706. This is Mr. Steyer's case. Looks like closed pretrial.
Yes, this is post-conviction matter, but it's on the pretrial docket.
Mr. Anderson, it's an excellent report.
Thank you.
You're doing very well. And I'm especially optimistic in seeing you get the help you need. It's been a long time coming.
Yeah, no, that's right. Thank you, sir.
You're very welcome. Mr. Steyer, where are we headed from here?
I would assume that the court intends to keep Mr. Anderson on the pretrial docket for at least a brief period, so I would leave it to the court's discretion what sort of a time frame we want to come back, and then I'll look at my availability.
November 10th?
I have a jury trial that day right now, Your Honor. I actually have jury trials the 10th, 14th, 17th,
How about the 3rd?
and the 3rd.
10th, 14th, 17th, 24th?
I'm here, Your Honor.
All right, found one. All right, we'll come back on November 24th for review for pretrial.
Thank you. Good job.
Mr. Anderson, keep it up.
Yes, thank you, guys.
Yeah.
State of Ohio versus Austin Davis, case number TRC 25-1966, A, B, and C.
So the State of Ohio versus Austin Davis, TRC 25-1966, A, B, and C. This is Mr. Steyer's case, set for pretrial.
Your Honor, I filed for discovery on this matter. I've gotten the written discovery, but there's been a slight delay in getting the video, so we're going to need to come back on this. This is a alleged refusal case. I've already filed for discovery, so I think time constraints are a moot point until the video is provided.
We'll come back November 24th as well, so time later here. Mr. Steyer.
Write that date down.
Pretrial 10 a.m.
Thank you. November 24th, 10 a.m.
And check with Miss.
State of Ohio versus Karen Hosey,
Thank you.
case number CRB 25-546.
Your Honor, Mr. Hosey's mother is the alleged victim, and she has informed me this morning that he is at the urgent care. So I'm going to ask for a continuance on this matter, and I've asked her to make sure that he has proof of that when he comes back. So I don't know how long the court would be willing to go out.
This is State of Ohio versus Garrett Hosey, CRB 25-546. All right, Mr. Field? Looks like you may have a...
So this is his mother, she's also the victim, and she says he had some teeth pulled.
He had 60, so he's in extreme pain and urgent care. Which is what my mother said. That's who he talks to, my mom.
So I'm here Friday, I'm here next Friday, I'm here the following Monday. I've got a few days available.
So he was supposed to submit himself for an assessment for substance abuse and mental health treatment, and apparently he went to the assessment but left without completing it. So we're kind of concerned about that. I believe it would be a good idea if we got him back here as quickly as possible to reset it. In fact, if Mr. Steyer is available even on Friday.
I'm here Friday.
All right, set this back on October 10th for a pretrial, 10 a.m. And we'll order him to provide proof of his visit to urgent care at that time.
Thank you.
All right, thank you.
State of Ohio versus Joshua Literal, case number TRC 21-1046.
So State of Ohio versus Joshua Literal, PRC 21-1046, Mr. Steyer's case that has a good time.
Your Honor, we're going to need to continue this matter. I'd like to see if we could come back a little sooner than we talked about on the last couple. Would the 27th be okay, Your Honor?
27th will work, October 27th.
Yes, Your Honor. And we'll waive time constraints.
I'll find time waive. After Mr. Literal, we'll be back October 27th at 10 a.m. for pre-trial.
Thank you. Now, we'll call it out. We're going to get a suppression. I'll explain to you later. 27th, 10 a.m. You're welcome.
State of Ohio versus Christian Orsbon, case number CRB 25338.
All right, this is State of Ohio versus Kristen Orsbon, CRB 25338. This is Mr. Steyer's case set as a pretrial.
And Your Honor, this is a cross-filing with Jeremy Hensley, who I think may also be set for today.
What's the name?
Hensley. And this was a 90-day continuance. My understanding is there have been no further problems. I think we were looking for one set of court calls. I'm not sure if either of you guys take a court call.
State of Ohio versus Jeremy Hensley, case number CRB 25339.
All right, this is State of Ohio versus Jeremy Hensley, CRB 25339, Mr. Morrison's case set as a pretrial.
And it was Mr. Hensley that had agreed to pay the court costs in order to get the dismissal.
Yes, sir.
He's nodding, so apparently he's got the money to do that today, and I guess there's been no further problems. We're okay with dismissing these, Judge.
Okay, so I probably should put on the record here that I do have a conflict. I currently represent Ms. Orsbon. I'm familiar with their cases. The case is basically resolved that I represent them in. However, I think that if the parties are willing to waive that today, then I think we could proceed, given this is an agreement. But I just did want to put that on the record that presently I do represent her.
On Ms. Orsbon's behalf, we will waive any conflict.
Okay.
Thank you, Mr. Judge.
State.
We waive.
All right, in CRB 25338, Mr. Orsbon's case, at state's request, this matter will be nollied. And on Mr. Hensley's case, CRB 25339, at state's request, this matter will be dismissed upon payment of costs. Mr. Hensley, can you pay this cost today?
Thank you.
Dismissed upon payment of costs.
State of Ohio versus Tyler Warren, case number CRB 25583, A, B, and C. Tyler Warren.
All right, this is case number CRB 25583, A, B, and C, State of Ohio versus Tyler Warman. Mr. Steyer's case set for pre-trial. Mr. Warman has not appeared.
I've not seen Mr. Warren yet. Let me check and see if he's checked in.
Okay.
He did not check in this morning, Your Honor.
All right. BA Being that the time's now 10:55 a.m. If no one hasn't checked in, the failure to appear, capious issue in 7 days.
Thank you, Your Honor.
Thank you.
State of Ohio versus Mohammed Marir, case number TRC 251741, A and B on the recall.
All right, this is State of Ohio versus Muhammad Marir, PRC 25-17-48. Mr. DeLauder's case set as a pretrial.
Judge, you indicated there are two cases
Sorry,
pending.
PRC 25-18-36, A and B as well.
And Judge, I believe we've got this resolved. So I met with Mr. Heald a couple times on this, most recently yesterday, and then again this morning. But I believe the state's willing to dismiss the entire second case, the one filed later in time, based on Mr. Marir's plea of guilty to the violations in the first case. I've talked to Mohammed about that. He wants to take the state up on its offer, and so he wants to change his plea based on that in the first case to a no contest plea with a stipulation to guilty finding.
Mr. Heald?
Your Honor, the second case arose because it was the same officer that arrested him on the first case, and he went under the assumption that Mr. Marir's license was administratively suspended out of the first case, but actually the court had released the ALS suspension because of the technicality of the paperwork not being filed in a timely manner. So really his license was valid the second time around, and that was the basis for the stop. So we felt that this is an appropriate outcome considering, and also I think factually and evidentiarily speaking, that the first case, with 1746, is that the first case?
1741.
1741 is a better case for us anyway, so we're okay with the dismissal of the second case upon the plea to the first case.
Okay. Well, we'll start with the 25-1741. Mr. Marir, this is the case that arose first in time on this. Mr. Lauder, how would your client wish to plea?
No contest, Judge, and he'd stipulate the facts sufficient for a guilty finding.
Okay. Mr. Marir, is that correct?
Correct.
All right, I'll accept your no contest plea, and I'll find you guilty based upon the stipulation. It'll be a $500 fine. I want you to pay the court costs. 20 days of jail. I'll suspend all 20 days on the condition that you go to the 3-day driver intervention program. Be 30 hours community service. 2 years level 4 probation. Be a 1-year license suspension. Dating back to the offense. And did he have insurance at the time of that, Mr. Ballard?
He did, Your Honor.
All right, then we can provide proof of that to the clerk today.
He's got it, I think he's got it with him. Yeah, he's got it with him.
Okay. Mr. Ware, if you can't provide that by the end of business today on the insurance, you'll have to deal with the B&B, and it's a lot tougher to deal with that at that time. So if you can provide that to the clerk before you leave, that'll save you a lot of.
I'll have him do that before he leaves, Judge. And I think, I understand your order, Your Honor. I think the state was agreeable to a 6-month license suspension. Would that be okay with the court? And I believe the state didn't have an opposition to Mr. Murray having driving privileges. He drives a lot for work.
Mr. Hill?
Both of those things are correct, Your Honor.
Okay. Well, I'll impose the 1 year, but I'll suspend the second 6 months for providing he can show that he's got the insurance on there, as well as Mr. Hill or Mr. DeLauder could provide an entry on the driving privileges and note in there that it'll be contingent upon him showing valid insurance.
Thank you.
And the B case on that,
which is
Stiltner, Jackie Stiltner.
Was a Mark Lane
We'll not leave that.
$20 fine.
Thank you, Your Honor. May I approach?
Or, no, sorry, he not. Did you not?
I said no.
I apologize, I didn't hear it. The B
Well, I
case
said
is
at the
not-
same time that you actually pronounced it, and I'm like, well, okay, whatever.
All right, and then on the 25/18/36 A3, the A and B case will be nolly at state's request based upon the plea and the evidentiary issue that it would likely, sounds like the stop might have been bad in that case, so.
Thank you, Your Honor. May I approach? I've got that entry on.
May.
I'll have him see the clerk now.
All right. Mr. Maria, you're going to need to see probation before you go, and the clerk about your insurance issue.
Your Honor, thank you.
All right,
Thank you, Your Honor.
Thank you.
All right, I'll meet you out there.
All right.
State of Ohio versus Connor Abrams, case number TRC 25-2107, A, B, and C.
This is State of Ohio versus Connor Abrams, PRC 25/2107, B and C. Mr. Delaw's case,
Judge, we've got a proposed resolution in this case. Upon review of the evidence, it appeared that this was a refusal case, but Mr. Abrams did submit to a portable breath test, which rendered a result below the legal limit. However, he's under the age of 21, and so the state's agreeable to amend the charge in this case to a violation of 451119B, OMVUAC. And to that charge, my client intends to enter a plea of guilty.
There was a proposed resolution on the matter.
My understanding from talking to Mr. Hill, Your Honor, is that they would be requesting a 90-day license suspension, a fine. I think the maximum fine is $250, I think.
That's correct, Your Honor.
All right. So you're moving to amend this to 451119B?
That's correct, Your Honor.
All right. I will accept that amendment upon Mr. Abrams entering guilty plea. Is that what you wish to do?
Yes.
All right. I'll accept your guilty plea and your guilty finding. I will It'll be a $200 fine. Only to pay the court costs. It'll be a 90-day license suspension dating back to the date of the offense. The
August 23rd, John.
10 days in jail. I'll suspend all 10. We're going to have a review for March 13th, 2026 at 9 a.m.
What was the date on that again?
March 13th. There'll be 30 hours community service, 2 years level 4 probation. And he'll have to attend the 3-day DIP school
You will?
as part of this.
I did not discuss that with him. I didn't realize that was a requirement on a M4.
Well, even if it's not a requirement, I'm going to order him to do it because of his age.
Can I have just a second?
No.
He thinks he can try to take time off to do that, if you'll give him a little bit of time.
It's going to be part of his probation, so he'll have time to do it. This isn't contingent upon him doing it first on this case. It's just going to be ordered. Mr. Hill, any position on the B&C cases?
No, I don't think any position on that.
Be a $30 fine on the B case and a $20 fine on the C case.
Your Honor, could he have occupational privileges? He does work full-time.
He may, I'll give him privileges for occupational, medical, to attend the DIP school and community service. He'll prepare an entry.
All right, I'll do that.
On that.
Thank you, Your Honor.
All right, thank you.
Meet me down in the lobby. I'll have him meet with probation and the public.
State of Ohio versus Madeline Wine, case number TRC 25-2064 A and B.
This is State of Ohio versus Madeline Wang, PRC 25-7064A and B. Mr. DeLauder's case, settled for trial.
Your Honor, we don't have this resolved yet. Could we have one more pretrial on November 10th? And we'll know by then whether it's going to get resolved or not.
At defendant's request, I'll reset this matter for November 10th for pretrial at 10 a.m.
And then, Judge, just for your information, Mr. Hill has made a proposal in this case. I'm going to meet with Madeline after court here. If something happens and we get it resolved, I'll ask that it be recalled and we can be done with it.
Okay.
All right, thank you, Your Honor.
Thank you.
Just meet me in the lobby.
State of Ohio versus Bryce McGinnis, case number CRA 25-526.
This is State of Ohio versus Bryson McGinnis, TRC 25-2109, CRA 25-526. It is Mr. DeLauder's case, so for preliminary hearing and pretrial.
Your Honor, I believe we've got this resolved also.
The state's offered in this case to amend the felony charge to a violation of 2921-331A, which is a misdemeanor in the first degree. That's based on Mr. McGinnis entering a plea to the OVI charge. I've talked to Mr. McGinnis about that, and he is willing to change his plea to the OVI charge and to the then amended charge of failure to comply. I believe that's the state's offer, and I believe Mr. McGinnis would like to accept that.
All right, Mr. Gill?
And that is correct, Your Honor. The failure to comply, and I guess recently there was a new legislation that elevated that to a felony under certain circumstances where it's not necessarily a situation like the F3 where there's other dangers, lives in danger. So this was not that kind of a situation. And so we're willing to reduce that to a misdemeanor, and our recommendation on the OVI is that we tested a .116, so we believe this is just a kind of a standard run-of-the-mill OVI as far as the sentence that the court would order, and we would just ask for an extra fine for the failure to comply.
Okay. All right, you've heard what's been proposed here, Mr. McGinnis. How do you wish to plead on the, we'll start with the, well, I guess for both cases, how do you wish to plead?
Guilty.
All right, I'll accept your guilty plea and enter a guilty finding to the amended charge. We'll start with the OVI. All right, it'll be a $600 fine. Where you pay the court costs. There'll be a 1-year license suspension dating back to the date of the offense. 20 days jail. I'll suspend all 20 days if there's a 3-day DIP program.
Yes, sir.
I'll set you a review for April 13th, 2026 at 9 a.m. You'll have 30 hours community service, 2 years level 4 probation. It's noting Mr. Delauder didn't have insurance.
That he did?
That he did not. Let me make sure I'm correct on the ticket.
Your Honor, he's indicating to me that he did have and still does have valid insurance. He can get that to the court before close of business today.
Okay. If you don't have it to court by close of business, you'll have to deal with the B&B, which is going to take you a whole lot more time dealing with them than if you catch it before it goes in. Okay?
Judge, assuming he does have his valid insurance like he's indicated to you that he does today, would you be willing to suspend part of that driving license suspension? He does work full-time.
Any position on that?
We're not opposed to that, Your Honor.
All right, I'll suspend the second 6 months of the suspension, of the 1-year suspension, upon showing that he's got valid insurance today.
Thank you.
It's marked as, I don't see it on my computer, I don't have a B case on that.
There is no B case on it. It's charged as an A1A, A1B, so there's no B case. The second case, the CRA 526. It's going to be amended to 2921-331A. It's a misdemeanor in the first degree. Any recommendation on the fine, Mr. Field?
No, Your Honor.
All right. It'll be a $250 fine. I'll order the court costs on that one. There will be, we'll do 20 days jail, all 20 suspended. And I'll run this concurrently with the TRC 2109. And it'll be 2 years level 4 probation on that case as well.
Okay.
All concurrent.
Is that all from Mr. McGinnis, Judge?
That's all from Mr. McGinnis.
I'll have him.
He'll have the sound to go and make sure he's got the review date, April 13th.
April 13th.
And then to see if you need the probation before we go.
All right, thank you, Hunter. Okay, don't, I gotta wait for probation, I'll be right out there. Got me out first.
You may.
State of Ohio versus Allison Singer, case number TRC 252550, A and B. This is an arraignment.
So State of Ohio versus Allison Singer, TRC 252550, A and B. Ms. Singer, it's alleged on or about October 4th, 2025 in Rome Township that you were operating a motor vehicle while under the influence of alcohol or drug abuse or a combination thereof. That's an alleged violation of Ohio Revised Code 4511-19A1A. That is a misdemeanor of the first degree. Maximum penalty on that is up to 180 days in jail, a $1,375 fine, or 3-year license suspension. The minimum penalty on that is 3 days in jail or 3 days in a DIP school, driver intervention program, a $575 fine, and a 1-year license suspension. The B case, it's alleged on the same date, same township, that you were operating a motor vehicle and failed to drive it within marked lanes. That's an alleged violation of Ohio Revised Code 4511.33. That is a minor misdemeanor. The maximum penalty on that is a $150 fine and court costs. How do you wish to plead?
I'm not guilty.
All right, I'll accept your not guilty plea to both charges. Do you have another hired attorney?
No.
Are you working?
Yes.
All right, how much, are you paid hourly?
Yes.
How much do you get paid per hour?
15.
How many hours a week do you get?
28.
Any dependents? You qualify, I will appoint Attorney Luke Steyer to represent you. I'll let you sign a $1,000 signature bond.
Grab this here. Sign your name here, please.
And Mr. Steyer, I know you've got a kind of a hectic schedule.
I didn't catch what kind of a test there is in this case, if any.
Refusal.
Okay. If we could go with the 27th. Is that agreeable to the court?
We could do October 27th.
Right.
And if she hasn't been fingerprinted, I'll order her to go to the jail to be fingerprinted.
I'll explain that to her, Your Honor.
All right, Ms. Singer, we'll see you back on October 27th at 10 a.m. for a pre-trial.
I'm talking a couple minutes in the lobby, please.
State of Ohio versus David C. Berry, case number CRB 25569. David Berry.
So the state of Ohio versus David C. Berry, CRB 25569. This is Mr. Morford's case.
Charles
Time is
Berry.
11:22 a.m. Mr. Berry was excited to be here at 10 a.m. and it does not appear that he has appeared. Can you approach him? Okay. Well, it looks like Mr. Berry has refused the treatment that he was supposed to do, and so, Morford, anything you got to say on that?
No, Judge. I'm not sure where he's at or why he left treatment.
All right, I'm going to issue a capias immediately.
State of Ohio versus J. Sean Claiborne, case number CRB 25495.
The state of Ohio versus J. Sean Claiborne, CRB 25495. This is Mr. Morford's case, set in pretrial.
Well, let me have a look here. Fast. Let's see here. Is Kara Parsons here?
Judge, I think we're going to have a change of plea.
Okay.
No contest with the requisite stipulation of finding of facts for sufficient prayer finding of guilty.
All right, Mr. Claiborne, is that correct?
Sir.
All right, I'll accept your no contest plea. I'll find you guilty based upon the stipulation. Mr. Gill, is there a recommendation in this matter?
Yes, Your Honor, and this is with being consultation with the victim in this matter, Kara Parsons. She's concerned about his mental health and wants him to have an assessment and treatment. And our recommendation is 30 days in jail suspended, probation. She already has a protection order, so is that still in effect, the protection order? Okay, so she has that. And obviously, a caution to Mr. Claiborne to continue to stay away from her. He's stayed away since this charge was filed. We want that to continue.
Okay. Mr. Morford?
That's what my understanding of the agreement is, Judge, and my clients as well.
Okay. All right, there'll be a $100 fine. Already you paid court costs. 30 days jail. I'll suspend all 30 days. Did Mr. Claiborne do any time in jail? Did you do any time in jail?
Yes, sir.
How many days?
2.
All right, Mr. Gill, is that?
He's entitled to credit for that, yes, Your Honor.
All right, we credit 2 days. That'll be two years level 4 probation. As part of that probation, I'm also going to order you as part of the probation, Mr. Claiborne, that you're not to have any contact with Kara Parsons. Now, I'll caution you, Mr. Claiborne, now that you've entered a plea and been sentenced on this matter, a second violation of this elevates this to a felony charge. So if you have any further contact with her, I don't control what the state files ultimately, but the state can file it as a felony, can take it to the county police court. So I want to make sure you're aware of that. Okay. All right, you'll have a review hearing scheduled for April 13th of 2026 at 9 a.m.
Thank you.
State of Ohio versus Justin Higgins, case number TRD 213577 A and B, CRA 21911, CRB 2397, TRD 173025 A, B, and C.
This is State of Ohio versus Justin Higgins, TRD 213577 A and B, CRA 21911, CRB 2397, CRB 2911, CRB 173025, C. This is Mr. Morford's cases, and looks like they're set for pre-trial.
What do you want to do with all this stuff? I think that's what's back. Did you do it?
Yeah, I'm not gonna, like I had the tag I just picked up, that I didn't know it was. I just wanted,
Did you have a license?
no, it was suspended.
This 2021 receiving charge.
cases? Oh, okay. That's Berry's.
There's one I can't tell. It was still pending at all.
That one is the pending.
Is that being charged?
He paid it wrong.
With the CRA 2111.
Jasmine.
Okay.
She was driving a truck. I got very little on here as far as.
Yeah, that's all.
Your Honor.
You may.
It's okay.
Well, here's one of my issues that I have. Yeah, she's got these two old cases, Mr. Walker. He's not going to pay the thing. I think he's paid $5 since 2020. So I think I would probably go further, put this thing out there a bit to make sure he gets some work done. I think he was 60 hours community service and about $300 on each one of them. 30 hours and 460 on one. 30 hours and 385 on the other, always pays $5. So he's done nothing. All right, we're back on after a brief bench conference. I'll start with you, Mr. Keel.
Well, Your Honor, we're aware of the fact that Mr. Higgins has some things that he'd already been ordered by the court to do in the past, and he's almost done nothing, which obviously would be of great concern to the court. We have a felony charge pending here that is from December of 2021, so it's almost 4 years old. And we are up in the air about how we want to proceed with this. We may just go ahead and take it to the grand jury, but we're willing to hold on to that and make that decision at a later date. But first, we're going to find out some information about what happened to the truck, if there might be restitution due or something like that, and also to see if Mr. Higgins will do some of the things that he's already been ordered to do. And that could have an impact on how we want to proceed with this. We might end up agreeing to keep the case here. That's going to depend on several factors, but we're going to, I guess, expect that he's going to do some stuff for the court before we make that decision.
Okay, Mr. Morford?
Judge, we'd ask you for a chance. He's indicated to me that he's willing to do community service and make what kind of payments he can. If not, maybe he can work some of it off. But I hope he understands the urgency of this because it's been outstanding for some time, and I know the court's concerned about my performance.
All right, Mr. Higgins, I'm going to talk a little directly to you. You've got two old cases out there from 2020. And the only thing you've done since 2020 is pay $5. That's it.
Yes, sir.
So, had the state been willing to do anything with this case today, quite frankly, I would not have been. Because I don't have any faith at this point that you're going to do anything you've been ordered to. You effectively thumb your nose at court. So, if you come out next Saturday and do community service, it's double credit. So you get double the credit for the 1 day of service, but I'm going to need you to do some significant work here to show us that you're willing to do what you're ordered to do, or otherwise, state may take it to grand jury and then take it to felony court. The other thing that can happen is, potentially, I could convert your community service and fines to jail time and just put you in jail and complete your case. I don't really want to do that, but you're not leaving me a whole lot of choice. All right, Mr. Morford, how far out do you want to go?
Maybe a month, Your Honor.
What's your schedule look like for the 10th of November?
I'm here.
All right. I'm going to continue this to November 10th for a pretrial and preliminary hearing. And Mr. Higgins, if you show up and you've got 1 day of community service done, that's not going to cut it. The time has passed for half measures. So I better see some substantial progress. Do you understand?
Yes, sir. Is that showing up here, down here at Saturday, or?
You can show up down here. You'll need Saturday, you'll need to show up down here if you want double credit. Otherwise, if you have, there may be some other community service opportunities that you can pursue outside of that time. You'll speak with Mr. Cooper or Mr. Major about that. They can tell you what's approved and what's not. Or maybe even point you in the right direction to some other times. And you can work your fines and court costs off as well on community service once you get finished. All right. So you're back November the 10th for a pretrial and preliminary hearing at 10 a.m.
Real quick, Judge, I've got some information that you've been through.
Yes, sir. Yes, sir.
Yes, sir.
State of Ohio versus Rosemary Jingle, case number T-1925-1921.
This is State of Ohio versus Rosemary Jingle, PO's 25-1921. It's Mr. Morford's case set as a pretrial.
Yes, Judge, I was just sitting here trying to figure out what she's facing here. I believe it's the second offense, OVI.
It is not, it's a driving under suspension.
We're going to have a change of plea of that, Your Honor.
Okay. What plea would your client like to enter?
Guilty, Your Honor.
Is that correct, Ms. Jingle?
Yes, sir.
All right. Accept your guilty plea and or guilty finding. Can you get your license back?
In January.
Okay, so, all right, it'll be a $100 fine and court cost.
Do I need to get driving privileges from Columbus?
Well, hang on a second, Mr. Morford.
Driving privileges for medical.
Mr. Hill, is this a regular driving under suspension or is this a driving under OVI suspension?
Well, Your Honor, I don't have the file on that one. You have the code section that's...
Okay, let me... All right, Mr. Morford, well, this is driving under an OVI suspension, and so I presume your client probably wants to withdraw that plea. It's a mandatory 3 days in jail.
Yes, we'll withdraw that.
Okay, I'll allow you to withdraw it because I told you it was a regular suspension and not looking at it as an OVI suspension. So with that being said, where are we on this case?
Let's set it for another pretrial judge and let me get her in and speak with her.
Okay. How about November the 17th?
That's good.
All right, we set this for November 17th for pretrial 10 a.m.
Thank you, Your Honor.
Thank you.
I'll see you again.
State of Ohio versus Ryan Slayton, case number CRB 25588. Ryan Slayton.
So the State of Ohio versus Ryan Slayton, CRB 25588. Mr. Morford's case set as a pretrial today. Mr. Slayton does not appear. Time is now 11:43 a.m. Mr. Morford.
I'm not sure where he is, Judge. If I could have a week to try to get him in.
All right, there'll be a capias to issue in 7 days for failure to appeal.
State of Ohio versus Hunter Tooley, case number CRB 24385 A&D, CRB 24329, CRA 24328, CRB 24293, excuse me, 292, case number CRB 23147.
This is State of Ohio versus Hunter Tooley, CRB 24335 A and B, CRB 24329, CRB 24292, CRB 23147. We had, I believe,
He's in jail, maybe.
Your Honor, I believe he was on for Friday and he got out on OR bond and he failed his urine screen for THC.
that's correct. I believe
Did he go to treatment facility?
he's in,
Do we have anybody from Mendocino?
he was ordered to be assessed. I don't know if that's, probably hasn't happened yet at this point. Let's pass this a little later in the docket. Well, the time is 11:43 a.m. Mr. Cooley has not appeared. He was told that he needed to be here today, and he has failed to appear. So there'll be a bench warrant issue, capias issue immediately.
Baird, case number CRA 25612. Your Honor, he has been picked up by Wake County.
All right. The state of Ohio versus Jonathan Baird, Sierra 25612. I was informed that we put it on to make sure that he'd been picked up on a whole floor hearing. Mr. Baird has been picked up. This matter will be dismissed here.
Your Honor, we're ready to start calling some cases that would like it.
Okay.
State of Ohio versus Dylan Adair, case number CRB 25609. This is Mr. Stratton's case, and I believe he's on Zoom.
This is the state of Ohio versus Dylan Adair, CRB 25609. This is Mr. Stratton's case set as a pretrial. Mr. Stratton has appeared on Zoom, and we're waiting on Mr. Adair to get into the courtroom.
Yes, Your Honor, I had spoken, well, I had a text with Art today, and they're still working on this. They should be in contact with him today. I think we already have an order on to release him to Art.
That's correct.
So we can put this back on the docket for Friday. We should have a definite answer by that.
Well, let's hang on a second here, Mr. Stratton, because we are having difficulties getting your client into the courtroom. All right, Mr. Adair is now in the courtroom. Mr. Adair, I've spoken with your attorney who's on Zoom. He has indicated that he's spoken with Art today. They should be reaching out to you again today on this. I guess there's having some issues getting your bed, but apparently that has now resolved. We're going to put this back on for October the 10th for a pretrial at 10 a.m. With any fortune, you'll be released to Art today. Okay? I don't know exactly where they're at, but they're going to release you there, and then they'll be responsible for bringing you back to court. All right, thank you.
And Mr. Stratton, you're okay with the time waiver for the period of the continuance?
Yes, sir.
Thank you.
All right, I'll note for the record that Mr. Stratton has waived time for the period of continuance on behalf of his client.
State of Ohio versus Angela Pruitt, CRA 25623, CRB 256.4.
State of Ohio versus Angela Pruitt, case number CRA 25623 and CRA 25624. All right, Ms. Pruitt is being handed a copy of the charges. Ms. Pruitt, we're going to go through your charges here. One of them is a felony charge, so we can't take a plea from you today based upon that. But I will tell you, you have the following rights before the court. You have the right to remain silent. Everything you're doing here is being recorded. Mr. Hill, that's sitting right there at that table, is the representative from the state of Ohio. And if you decide you want to tell me something about this case, and it is against your interest to do so, he is sitting right there and will hear you, and it can be used against you later at your trial. You have the right to have an attorney. If you can't afford an attorney, I can appoint one to represent you at state's cost, and you have the right to have a preliminary hearing here in this court within 10 days of being brought in on this. You feel like you understand my explanation of your rights? All right. So Ms. Pruitt, in case number CRA 25-623, it's alleged that on or about October the 6th, not having been relieved from disability as provided in section 2923.14 of the revised code, you did knowingly acquire, have, carry, or use a firearm or dangerous ordinance, and the person has a drug dependency, is in danger of drug dependence, or has chronic alcoholism. That's an alleged violation of Ohio Revised Code 2923.13A4. Having weapons while under disability, that's a felony of the third degree. Felonies of the third degree, this particular felony of the third degree carries up to a maximum term of 3 years in prison and up to a $10,000 fine. In the CRV 2564 case, it's alleged on or about October 6, 2025, you did knowingly use or possess with purpose to use drug paraphernalia, to wit, 2 crack pipes, in violation of section 2925.14C1 of the Ohio Revised Code. That's possession of drug paraphernalia. That's a misdemeanor of the 4th degree. Maximum penalty on a misdemeanor of the 4th degree is up to 30 days in jail and up to a $250 fine. You have the money to hire an attorney. Are you working? Okay. All right. Well, I will appoint Attorney Butch Morford to represent you. Mr. Hill, do you want to be heard on the matter of bond?
Your Honor, the circumstances of this indicate anyway, or point in the direction that maybe there's some substance abuse issues that maybe she needs to deal with. This is a long statement, but we would be okay with an OR bond if it was accompanied by an assessment for treatment and have her follow whatever recommendations there are. We'd want to know what the assessment revealed before she was let out of jail.
All right, I see Ms. Taylor back there is raising her hand. I'm going to have her come back. She's going to assess you, and then we'll have you back out later in the docket to determine what your bond's going to be. All right? All right, we'll recall this case a little later in the docket.
State of Ohio versus Heather Robinson, case number CRB 24-281A and B.
This is State of Ohio versus Heather and Robinson, CRB 24-281A&B. Ms. Robinson is present here in the courtroom today. Ms. Robinson is alleged that on or about February 14th, 2025, that you failed to appear for a review hearing. Do you admit or deny that you failed to appear for your review hearing? Okay. And do you have a good reason why you missed your hearing?
The only my dad helped him fix that here, and he had all these criminal things going on, and I didn't know more now, so I just didn't want to go with the job out and
Okay. Well, if I were to have you drug screened today, you 100% you would pass.
And so for 70-something days, I just moved from another jail, so.
Okay. What jail did you come from?
Bryan County.
Is that where you live?
I live in Cincinnati.
Okay. How many days in jail have you done?
70-something days so far.
How many days have you done here in Lawrence?
Since Friday.
All right. Here's what I'm going to do on this. Now, what do you have to do out of Warren County
I'm done with them.
entirely?
I'm
Okay. Well, here's what I'm gonna do. I'm gonna have you here in spring, and then I'll have you back out. And if you're being honest with me, we may be able to wrap your case up today. Okay? If you're not, then there's gonna be a bunch more requirements you're gonna have to do. And you may not get out of jail today. All right.
Thank you.
Thank you.
State of Ohio versus Devin Stevens, case number TRC 25-2546, A, B, C, and D, CRA 25-628.
So State of Ohio versus Devin Stevens, TRC 25-2546, A, B, C, and D, and CRA 25-628. Devin Stevens.
He should be here.
All right, we'll try to call this again here in a few minutes.
Devin Stevens?
State of Ohio versus Cynthia Gannon, case number CRD 25-547. You want to listen to Mr. Stratton's case?
All right, this is State of Ohio versus Cynthia Gannon, CRD 25-547. This is Mr. Stratton's case. I don't know if Mr. Stratton knows that.
Should be on Zoom. Probably didn't know about this.
Yeah. All right, Mr. Stratton. This is State of Ohio versus Cynthia Gannon, and I'm sure that you didn't have this on your docket today. However, Ms. Gannon has been discharged from her provider, and I believe it's on a motion on her behalf, because I think she wants to potentially change providers. I was just handed a report, and I'll read through it real quick.
So if you look at hometown, you're just on page 2.
That's correct, Mr. Stratton. However, the clinical director there believes that she requires a higher level of care. So it wasn't, the clinical director believes she requires a higher level of care. So she was not discharged for any other reason other than that, based upon the assessment. She needs a medically managed facility capable of dealing with her needs. Ms. Gannon, do you have a place that you were proposing to go?
Yeah, I talked to the lady out here, and I think I'm moving in there.
Okay.
So I think, yeah.
Are you guys capable of providing that higher level of care? Because if you guys are in the same position that hometown is, and we'll be probably right back here in a month.
I believe it's our nursing services that will be more beneficial for her.
Okay. All right, Mr. Stratton, I presume you wouldn't have any issue then with her going to Focus then. They've got some nursing care that may help your client with that.
Well, she took a plea on 9/26, so this might be just on review though.
Yeah, it may be. Okay. Well, that would be fine then. Here's what I'm going to do. All right. Ms. Gannon, I'll make a note for the file that you're going to be attending Focus going forward. Put your report in the file so when we see that later, we'll know what has occurred here and that you're now at Focus. That is still part of your sentence. So you're going to have to continue there and do what they indicated, but it doesn't sound like you weren't doing what you're supposed to do, you just needed a higher level of care. So,
Right.
So I will allow that, and it looks like you have a review scheduled for November 14th, so we'll see you back at that time.
Okay, thank you.
All right, thank you.
Thank you.
Thank you.
State of Ohio versus Troy Dwayne Edwards, case number CRA 24594.
All right, this is State of Ohio versus Troy Edwards, Sierra 25594. Mr. Edwards is present here in the courtroom. Mr. Stratton is here via Zoom. And we're provided with an update report. Okay. Well, a little bit of a mixed report. Looks like you had a little bit of a hiccup, but it looks like you're back on track.
Yes, sir.
All right, so Mr. Stratton, when would you want to come back?
Probably sometime in November.
All right, is there a specific date that you're here that you know of?
Any Monday and Friday except the 3rd and the 10th, I believe. Yes, the 3rd and the 10th are both bad days.
How about the 7th?
Yep, that'll work.
All right, I'll set you back, Mr. Edwards, for November 7th, 10 a.m. for a preliminary hearing.
Mr. Stratton, you're okay with the time waiver for the period?
Yes, Mr. Hill.
Thank you.
All right, I'll find the time we've been waiting for the period of the continuance. Looked like there was a note that time was waived early on in the case, but I'll go ahead and note that for the record as well.
State of Ohio versus Daryl Cabarrus, case number CRB 25629.
All right, this is State of Ohio versus Travelers, CRB 25629. Travelers is present here today for his arraignment. All right, Mr. Cabarrus, it's alleged on or about October 5th, 2025, you know, in the cause of attempt to cause physical harm to John Cabarrus, a family or household member. That's an alleged violation of Ohio Revised Code Section 2919.25A of the Revised Code. It's domestic violence and misdemeanor of the first degree. Misdemeanors of the first degree carry a maximum of up to 180 days in jail and up to a $1,000 fine. How do you wish to plead?
Not guilty.
All right, I'll accept your not guilty plea. You have the money to hire an attorney?
No.
Are you working currently?
I'm on disability.
All right, what do you get a month on disability?
I get VA disability about 100%, which is about 4,000, and Social Security.
Do you have any dependents?
Yes.
How many?
I have one that's living in the house right now, Tavarian, and 4 others, but they're out of the house.
Okay. All right, I'll find that you do meet the requirements. Based upon that, I will appoint Attorney Steyer to represent you. I'll let you sign a $1,000 signature bond. Mr. Hill?
We're okay with that, Your Honor.
Are you seeking a protection order in this matter?
No, I'm not. I felt there was an intentional one. I just would like it for it to be dismissed honestly.
Did you post the bond already?
We're not prepared to do that today, but I'm already aware of her feelings about it, and we want to make sure that there aren't any more problems, so.
Okay.
If I may, Your Honor, I believe he's already posted a bond.
Oh, okay. I didn't know that. Okay, yeah, I'll put some there. All right, I'll just continue the bond then from, that was posted. If you haven't been fingerprinted already, you got to get fingerprinted. Mr. Cabarrus.
He was, Your Honor.
Okay.
And Your Honor, we're going to need to amend his surname. It's Cabarrus, Cabarrus.
Spell it again?
Cabarrus.
Okay, that's on the summons, is that, no, it's not on the,
It's not on the complaint.
okay, it's not, okay. The
Any-
complaint is mistaken.
Any objection?
No objection, Your Honor.
I'll find that the scrivener's error and that his, Mr. Cabros's name will be amended throughout the complaint to reflect that it's Cabarrus. All right, Mr. Steyer, when do you want to come back?
Relatively quickly, Your Honor. I think this is one that we're going to probably be able to move along. I'm here,
The 27th of October.
I'm here the 27th. Let's write that down there, please.
All right. I'll set you back for a pretrial, October 27th at 10 a.m. And Mr. Cabros, there's no protection order has been being requested at this point, so you can be in the home, you can have conversations, all of those things that you otherwise could do, and we'll see you back on October 27th.
Thank you.
State of Ohio recalls Devin Stevens, case number TRC 25-2546, CRA 25-628.
All right, sir, you're Mr. Stevens. All right, this is State of Ohio versus Devin Stevens, TRC 25-2546, A, B, C, and D, CRA 25628. All right, Mr. Stevens, we're here for your arraignment. We'll start with the TRC 25-2546, A, B, C, and D. It's alleged on or about October 5th, 2025, in Windsor Township, that you were operating a motor vehicle while under the influence of alcohol, drug abuse, or a combination thereof. That's an alleged violation of Ohio Revised Code 4511-19A1. That is a misdemeanor of the first degree. Maximum penalty on that is up to 180 days in jail and up to a $1,375 fine and a 3-year license suspension. Minimum penalty on that is 3 days in jail or 3 days in the driver intervention program, $575 fine, and up to a 1-year license suspension. On the B case, it's alleged that you failed to wear a safety belt on the same day, same township. That's a statutory $30 fine. It's an alleged violation of Ohio Revised Code 4511.263B1. On the C case, it's alleged that on the same date and same time that you failed to control your vehicle. That's an alleged violation of Ohio Revised Code 4511.202. That's a minor misdemeanor. Maximum penalty is up to $150 fine and court costs. And on the D case, it's alleged that you went left of center or outside your lane of travel on the same date, same township. That's an alleged violation of Ohio Revised Code 4511.25. It's a minor misdemeanor. Maximum penalty on that is up to $150 fine and court costs. On the CRA 25628 case, it's alleged that on or about October the 5th, 2025, you did operate a motor vehicle as defined in section 450101 of the revised code, so as to willfully elude or flee a police officer after receiving a visible or audible signal from a police officer to bring your motor vehicle to a stop. The operation of the motor vehicle by the defendant is the proximate cause of serious physical harm to persons or property in violation of section 2921331 BC5AII. That's failure to comply with the order of or signal of a police officer. That's a felony of the 3rd degree. Felonies of the 3rd degree carry a maximum penalty of up to 3 years in prison and up to a $10,000 fine. Do you have the money to hire an attorney?
Yes, sir.
Okay. I'll note that you're going to hire an attorney. You have appeared here voluntarily today. It looks like you've already bonded out. Mr. Heald, I'll go to you first on the matter of bond. Looks like
Surprised he hadn't already filed,
there's a $3,500 bond posted by Mr. Sowers in this matter at this point.
Well, I guess we'll be satisfied with that, with what's already been posted.
Okay. I'll continue the bond. Mr. Stevens, how long, you have the right to have a preliminary hearing on this matter within 10 days, but you're going to hire your own attorney, and that can take some time. So first thing I would ask you is how long do you think you need to hire an attorney?
About a couple weeks, probably.
Okay, now, if I give you a couple weeks to do so, which you're not in jail, so you're not really in any jeopardy at this point, but if I give you a couple weeks to get an attorney, your preliminary hearing would have to occur outside of the 10-day period. Now, would you want to waive that time period to have the preliminary hearing so that you can get an attorney? Or do you want to keep, if not, I'll have to set it within that time frame, whether you have a...
I want to wait till he's here with me.
Okay. All right, so let's go out. I'll set you back in 2 weeks on October the 20th. Or actually, I'll give you 3 weeks if you want 3. It's a little better for the court schedule.
All right.
I'll set you back for November, or for October 27th. For pretrial and preliminary hearing. And I'll note that you've waived time on preliminary hearing.
Your Honor, I've prepared a time waiver for him to sign too.
Okay. You'll need to sign, review, and sign the document that Mr. Hill's printing, where you're waiving that time period on the preliminary hearing.
Yes, sir.
Okay? All right, so I'll see you back, once you've signed that, I'll see you back on October 27th for a pretrial and preliminary hearing.
Okay, do I take these papers with me?
Yes, that's your copy.
Alrighty. Thank you, Your Honor.
You do sign this. There at the bottom, where it says defendant.
State of Ohio versus Geneva DeBoard, case number CRA 25488. This is Mr. Holt's case,
All right, this is State of Ohio versus Geneva DeBoard, CRA 25488. In Mr. Holt's case, we have Mr. Holt in court.
Your Honor, he may be back in the holding area. Mr. Holt, the attorney.
This is State of Ohio versus Geneva DeBoard, CRA 25488. I've not seen her.
I've met with her, and QRT met with her. She's not a walker, she just got out of the hospital.
Okay, you want to pass this for a few moments?
She left? Okay, I'll go try to find her, I guess.
Here, we'll pass this a little later to the docket. I think you may have a couple other cases here, Mr.
State of Ohio versus Brian Elliott, case number CRB 25525, CRB 25527.
All right, this is State of Ohio versus Brian Elliott, CRA 25525, CRB 25527. Mr. Holt's case set for a preliminary hearing. All right, it's a very good report. All right, Mr. Holt, when would you like to come back?
Mr. Hill, what are you thinking? I think he's done well the past couple reports. Maybe after Thanksgiving, would that? Would the first work, Your Honor?
December 1st would be fine. All right, this matter will be continued to December 1st for preliminary hearing at 10 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
No.
State of Ohio versus Rusty Ratliff, case number CRA 25630.
Mr. Holt, you're not taking the conference call right now. I didn't think so. All right, this is State of Ohio versus Rusty Ratliff, CRA 25630. Mr. Ratliff, you're here on what looks like to be a warrant for grand theft of motor vehicle out of Claremont County. You have the right to have what's called a Rule 4 hearing to determine whether or not you're the same Rusty Ratliff that Claremont County is looking for. If you wish to have that, we'll reset this matter and give them an opportunity to state to get who they need here, and we'll have a hearing on that matter. Otherwise, you can waive that hearing, saying, hey, that is me, and I want to get back to Claremont County and face it. If you waive your hearing, I will give Claremont County probably a week to come get you. If they don't come get you, I'll have you back out here, and then unless there's some compelling reason that they haven't come to get you, within that time frame, you'd be released at that time. So I guess the question would be, is do you want to have a Rule 4 hearing, or do you want to waive that right to Rule 4 hearing?
Might as well waive it. I'm already got them on there, so
Okay.
when I get back there, they'll restate it.
All right.
When I get back, I say go.
All right, there's a place for him to sign, waiving on this. I will set you a bond at $5,000 cash surety, and I will order Claremont County, I'll give them a week from today to come pick you up, and then we'll set this matter back for October 14th. I'll give them to October 14th because there's a holiday on the 13th.
Yeah, so if I find out here, what's going to happen, my charge there, will they give me any more, is
You still have, if you bond out here, you'll have to show proof that by the 14th you turn yourself in up there. Now that may be, they may put you back in jail there, so you may pay the $5,000 and they may put you right back in jail when you get there. I don't know what they're going to do with you when you get there, but if you post the bond, you've got to appear by that date. If you do not post the bond, I'm giving them until the 14th to come get you. I'm resetting you here for the 14th that morning at 10 a.m. And then if they haven't picked you up, they'll have you here, out here, or on Zoom, and we'll determine at that point whether the state has any compelling reason why they haven't come to get you. If they do not have a compelling reason, I would anticipate you be released at that time. Now, that wouldn't get rid of your warrant out to Claremont County, so you could be released and could be picked up again later that day, but won't stop you if they don't come get you, but I would imagine they'll probably come get you. All right. Thank you. Yes. Oh, okay, well, let's have him back out, sorry, I thought that was the way they were signing. Oh, then he signed it.
State of Ohio versus Al Hassan Asari, case number CRA 25-631 and CRB 25-626.
All right, sir, Municipal, sorry. All right, this is State of Ohio versus Al Hassan Asari, CRB 25-626 and CRB 25-631. Ma'am, what's your name?
He was in Restoring Hope Recovery Care.
Okay. All right. Well, Mr. Sorry, we're going to go through, it looks like you've got I'll start with the CRB 25-626 case. It's alleged on or about October 4th, 2025, you did knowingly cause or intend to cause harm to James Matthew Caldwell Jr. That's an alleged violation of Ohio Revised Code 2903-13A, assault, that's a first degree misdemeanor. Maximum penalty on that is up to 180 days in jail and up to a $1,000 fine. It's also alleged that you have a warrant out of Pickaway County for a probation violation, and they're asking that you be held on that without bond. Now, you have a right to have an attorney in this matter, both on the new charge and on the Rule 4, which is to determine whether or not you are the Al Hassan Asari that Pickaway County is looking for. So we'll start on the Rule 4 with that. We'll talk about that a little bit, and then we'll work on the other issues. So you do have a right to have an attorney in that, and if you can't afford an attorney, I can appoint one to represent you. However, they're requesting no bond on that, and I presume that would be, it's on the Circleville Municipal Court is where it's out of. So I'm presuming that's a misdemeanor warrant of some sort there, but I don't know what you're facing there other than it's generically termed as a probation violation, but I don't know what for. You have the right to force the state to prove that you are the individual that they're looking for out of Pickaway County. However, I am inclined to grant their request for no bond in this matter. So if you want to do that, you're probably going to be waiting until we can come back for that hearing to determine that. And I don't know what will come out of that hearing. I don't know whether they're going to be able to prove it or not. There's a process that they have to go through to do. You also have the right to waive that and say, hey, yeah, I'm the guy, send me back, let them have to come get me, and I'll go face it. Because again, I don't know what they intend to do with you once you're there. I don't know if they're just going to put you back on probation, whether, I have no idea. So in regards to, I want to go through a couple things with you in regards to the new charge. So I've already kind of arraigned you on it, told you the maximum penalty involved with that. So I'm going to, in a moment, ask you for one of 3 pleas on that charge. You can enter a plea of either guilty, which means you're admitting that you making a complete admission that you committed the offense charge. You can enter a no contest plea, which means you're not admitting that you committed the offense charge, but you're not contesting the facts surrounding the circumstances, and if I believe the state would have enough evidence based upon the negative, I could enter a guilty finding. You can also enter a plea of not guilty, which preserves all of your rights before the court. And I would set you a bond of some sort for that case, but it would kind of be academics along with the other cases we noted. You have the right to remain silent. We're recording everything in here, so if you decide you want to tell me something about the case, the state will potentially use that against you if it's not in your interest. You have the right to have an attorney. I can appoint an attorney if you can't afford one yourself, and if you qualify. You have the right to have a reasonable bond on your charge, and you have the right to force the state to prove each and every element of the offense charged beyond a reasonable doubt. You feel like you understand my explanation of your rights for the court? All right, so knowing those rights on the assault charge, how do you wish to plead?
I'm going to say, guilty with an explanation.
All right, I'll give you the opportunity to explain. So I will accept your guilty plea, and I'll enter a guilty finding. With that being said, I'll let you give me an explanation of what you will say on your behalf.
On that morning, I said it was the 4th.
I believe so, yes.
I was in the living room of the house that I was going home on County Road 1. I was watching TV. I can't remember his name. The dog usually comes back and he sits on the couch. He just lays on the couch all morning, all afternoon, all night watching TV. I took my flip-flops upstairs. Like just finished cleaning my room. He asked me, was I coming back downstairs, kind of fine. And I said, yeah. And when I got back down there, he was like mumbling something. So I said, well, listen, man. I see you do this all the time. I mean, you should be considerate of other people that would like to watch TV. This is all you do since I've been here. It's not even been a week and you do this every single day. So I took off walking to the kitchen. While I walked to the kitchen, he was yelling something I couldn't really hear him. But I heard him when I come back into the living room. And I was like, what did you say? And I don't know if I can say it in the courtroom, but he said, you heard what the F I said, you effing nigga. And he had his fist balled. And I was like, man, you really want to do this right now? You heard me, you fucking nigga. So when he stood up with his fist balled, I felt it, I popped. That was it.
Okay. Well, that being said, I mean, you may have a valid defense. I mean, I don't know what the state's side of the story is going to be or what Mr. Caldwell might testify to or otherwise. You may have a valid defense. Are you sure you wish to enter a guilty plea?
I mean, I did hit him, you know what I'm saying? I could have walked away, but I walked away early and he was saying stuff too. But I hit him.
You sure that's what you want to do?
If I do that, would this be over with today? Like,
Well, maybe, maybe not. I mean, I would have to sentence you, and then, but I don't know what the state's going to recommend, and at this point, and I don't know, you know, I've heard your side of it. I haven't heard what they're going to argue at this point, so I don't, you know. I mean, it may be done today. It may be that you've got a sentence to serve, but, you know, but that's.
I mean, I just got a new job.
Because otherwise, I would set you a bond in the matter. Now, we'll talk about the Rule 4, whether you go back to Circleville or not, but I would set you a bond in this matter, and you would come back on another date, and you have the possibility of potentially getting an attorney, and we'll be appointing an attorney if you qualify, and I just want to make sure that you're sure that's what you want to do. All right, I'll accept your no contest plea, but here's the problem I got is you, again, may have a valid defense. I don't even necessarily know that I can make a determination based upon that. So here's what I'm going to do. I'm going to withdraw your plea. I'm going to enter a plea of not guilty for you at this point. Do you have money to hire an attorney? All right, you said you got a job, are you working currently?
My job would have been starting tomorrow.
Okay.
8:56.
All right, I'll appoint Attorney Steyer to represent you. Mr. Steyer, this is an assault, and there may be a valid defense in this matter based upon what he just indicated on record. He had entered a guilty plea, and I allowed him to withdraw the guilty plea based upon what he had indicated to the court at that point. Mr. Hill, at least as far as the misdemeanor case, obviously, there's also a Rule 4 out here, Mr. Steyer. They're asking that he be held without bond on that. But as far as the misdemeanor goes, Mr. Hill, matter bond.
Your Honor, the state would request a $2,500 cash or surety bond.
Okay. Mr. Steyer, this apparently alleged incident happened at a treatment facility. I don't know if you've got...
I need to make sure I didn't represent the alleged victim, because the name is a surname that I've got several people with at the moment, but I don't.
Okay.
Yeah, can I have just 1 second, Your Honor?
You may.
He's got a Rule 4 too.
I'm sorry.
He's got a Rule 4 too.
I understand that.
We're just only talking, they've requested no bond on the probation violation of the other county. We're just solely talking about the bond on the misdemeanor that's present, the new charge that's present here.
But I don't think no bond is legal on that without a no bond hearing, so I would ask that whatever bond gets set on both matters. However, it appears he was inpatient at a facility. He'd be willing to go to another facility if there's anyone that's about that.
Well, with the...
I didn't know that might change the state's mind on cash surety component if he's willing to go to the inpatient rehab.
Honestly, I think that it's most important that he get back to, is it Pickaway County? Is that the county he's out of? That's where he has apparently a probation violation or
Would you be willing
something.
to give him an OR bond on this and let him go back, let them discuss?
This was an assault that occurred at the facility. What we're going to do between now and the next hearing is find out if there's restitution due. And if he's in jail, then he probably will have accrued enough jail time for our recommendation to the court.
What's the request?
The request was $2,500.
If we made it 1,000 cash surety, I believe you might make that up with 2,500. You would say we found money to come up with this right at that amount. Lately, the bonds have been charging more than 10%. So I would ask for a $1,000 cash surety bond. That gives the state the cash surety bond in which the property the possibility of making. I would ask to cover both matters, and I'll discuss with them what's involved with this. Isn't it?
It's Pickaway County, it's a municipal court there.
So that would be my request, Your Honor.
Okay.
Your Honor, our request for a $2,500 cash or surety bond was based on the fact that Pickaway County was asking for there to be no bond. So if the court's going to set a bond on that as well, we would want the bond to be $2,500.
Sorry?
I made my argument, Your Honor. I didn't know anything more to say to that.
Here is what I'm inclined to do. I'll set bond at $1,500 cash or surety on both cases, but that he only be released to well, I guess the question would be, does he want a Rule 4 hearing?
Well, I haven't discussed that with him, Your Honor. I'm going to discuss that separately.
Well, here, why don't we do this? Let's let you discuss it with him and have him back out, because my bond potentially affects how all of that goes as well. So I'll indicate that my intention would be that he could be released to a separate assessment to a separate treatment provider and second the lower bond. However, if he's got to go to another place, he has to go there and then back for another town, most likely, if he's fully being released to the treatment provider. When I said on the transport.
I mean, someone said, well, I would discuss that with the various providers.
Okay. Is there anyone that would want to assess Mr. Starr? All right. We'll have you go ahead and assess him while, after Mr. Steyer speaks with him, and then we'll have him back out.
Great.
State of Ohio versus Jason Reed. Case number TRC 252545 AT&C, CRA 25632, CRB 25633.
All right, this is State of Ohio versus Jason Reed, TRC 2545, A, B, and C, CRA 25632, CRB 25633. All right, Mr. Reed, we're going to go through your charges here, and because there's a felony charge, I'm not going to take a plea, but we're going to go through the felony charge first with you. But first, I want to go through some of your rights in court. You have the right to remain silent when we're recording everything here today. If you say something against your interest, it can be used against you. You have the right to an attorney. You can afford an attorney. I can appoint an attorney to represent you. You have the right to reasonable bail in this matter. You have the right, of course, to stay in Ohio through each and every element of the offense charge on misdemeanor beyond a reasonable doubt. You have the right on felony to have a preliminary hearing within 10 days on that. So on the CRA 25632, Mr. Reed, it's alleged that on or about October 5th, 2025, you would knowingly obtain, possess, or use a controlled substance or controlled substance analog, and said drug involved as a compound mixture, preparation, or substance included in Schedule 1 or 2, to wit, 5.9 grams of methamphetamine. The amount of said drug equals or exceeds the bulk amount, or less than 5 times the bulk amount. It's an alleged violation of Ohio Revised Code 292511 AC1B of the Ohio Revised Code. That's possession of drugs, a felony of the 3rd degree. Felonies of the 3rd degree carry a maximum penalty of up to 3 years in prison, up to a $10,000 fine. On the CRB 25633 case, it's alleged that on or about October 5th, 2025, you did knowingly use or possess with purpose to use drug paraphernalia, to wit, 1 glass smoking pipe, in violation of Section 292514C1 of the Ohio Revised Code. Possession of drug paraphernalia, that's a misdemeanor of the 4th degree. Misdemeanors of the 4th degree carry a maximum penalty of up to 30 days in jail and up to a $250 fine. In case number PRC 252545, in the A case, it's alleged on or about October 5th in Rome Township that you were operating a motor vehicle under the influence of alcohol, drug abuse, or a combination thereof, and that you had a prior within the last 10 years. That's an alleged violation of Ohio Revised Code 4511-19A1A. That is a misdemeanor of the 1st degree. The maximum penalty on that is up to 6 months in jail and up to a $1,375 fine and 3-year license suspension. The minimum penalty on that is up to, 10 days jail or 5 days jail and 18 days home confinement, a $575 fine, and a 1-year license suspension. Do you have money to hire an attorney? Are you working currently? All right. I'm going to all right, I'll bring Butch Morford to represent you. Mr. Hill, you want to be heard on the matter of bond?
Your Honor, we request a $10,000 cash assurance bond.
All right, I'll tentatively set bond at $10,000 cash surety. Mr. Morford, I'm going to let you speak with Mr. Reed, and then we can have it back out on the matter of bond.
Brilliant. I got a copy.
You got a copy already?
Thank you.
No problem. And we'll set another hearing based upon what the bond is and your availability. Thank you.
State of Ohio versus Eric Downing. Case number CRB 25627, CRA 25634.
All right, this is State of Ohio versus Eric Downing, CRB 25627, CRA 25634. Mr. Downing, we're going to go through your charges here. Since you have a felony, I cannot take a plea on this. However, you have the following rights to record. You have the right to remain silent. Anything you say is being recorded and can be used against you. So if you say something against your interest, the State of Ohio can use that at a later hearing against you. You have the right to an attorney. If you can't afford an attorney, I'll appoint one to represent you if you qualify. And you have the right to have a preliminary hearing within 10 days in this matter. In case number CRA 25634, it's alleged that you, in Fayette Township, on or about October 3rd, 2025, did knowingly create a substantial risk of serious physical harm to another, to wit, Chelsea Dollarhide, by means of strangulation or suffocation, in violation of section 2903(18)(b)(3) of the Ohio Revised Code. That's strangulation, that's a felony in 4th degree. Felonies in 4th degree carry a maximum penalty of up to 18 months in prison and up to a $5,000 fine. In CRB 25627, it's alleged that on or about October 3rd in Fayette Township, you did knowingly cause or attempt to cause physical harm to Chelsea Marie Dollarhide, family or household member. That's an alleged violation of Ohio Revised Code section 2919.25A, domestic violence. It's a misdemeanor of the 1st degree. Misdemeanors of the 1st degree carry a maximum penalty of up to 6 months in jail and up to $1,000 fine. Do you have money to hire an attorney?
Yes, sir.
Are you working currently?
Yes, sir.
All right. Are you paid hourly?
Yes.
All right. How much do you get paid per hour?
73 years.
How many hours a week do you get?
32, 35.
You're going to qualify for appointed counsel. I'll appoint attorney Luke Steyer to represent you. It's okay. We'll let him know when he comes back out on this. Mr. Hill, you heard on the matter of bond at this point.
Your Honor, the state would request a $5,000 cash or surety bond and a protection order.
All right. I'll set bond presently at $5,000 cash as surety in the matter, and there'll be an order of protection for him to stay away from Chelsea Dollarhide. Steyer, just appointed you on this. It's a strangulation and a domestic violence.
Have I been appointed to this? Oh, I didn't realize that. Okay.
I was just gonna give you the file because I assume you're gonna talk to him before. I assumed you were gonna need to talk to him about bond, sunset bond, the 5,000 cash surety. There's gonna be temporary protection order, no contact.
Okay, I'll take a look at it, Your Honor.
I didn't want to pull you away from, we're a little short-staffed on the attorney side today, so I didn't want to pull you away. We were just going to give it to you when you came back out.
Okay, thank you.
All right, we'll have this back out on the matter of bond here shortly.
State of Ohio recalls Heather Robinson, case number CRB 24281, A and B.
All right, this is State of Ohio versus Heather Robinson, CRB 24281, A and B. We're here. Ms. Robinson had admitted to missing her review hearing back in February of 2024. We had a drug screen. Ms. Robinson, you told me that you were going to test negative for all substances. You know what you tested for?
I shouldn't have known.
You have nothing in your system, so I'm going to complete your case by jail time. All right. You'll be, as far as Lawrence County goes, you're done with here unless you've got something in another court here in Lawrence County. All right, your case is closed here.
All right, thank you.
Thank you.
Your Honor, we will take a short recess because the other attorneys that had these other cases are tied up.
Okay. Well, does Mr. Holt have one of them?
Yes,
Let's go ahead and call it, and that'll give them a break.
State of Ohio versus Uriah Brown, case number CRA 25593, CRB 25594.
We may want to recall this.
Well, we wanted to go ahead, and unless you've got a reason you want to recall it up a little later, we've got, they're tied up, our attorneys are tied up, so we would have to take a recess.
Okay. I know Jasmine will speak with the she's on the phone now.
Okay, well, we'll hold off then.
I've got two other cases. Excuse me?
What are your other two cases?
Neither the board do, which,
Okay.
and Jasmine still.
I don't have to still, I don't even have a file for it.
I don't have it on the docket.
That's mine, so I'll grab it on file. So just be the, all right.
Recall the other one.
State of Ohio versus Geneva DeBoer, case number CRA 25488.
All right, this is State of Ohio versus Geneva DeBoer, CRA 25488. It's Mr. Holt's case, it's subject to preliminary hearing. Mr. DeBoer was here earlier, but has since left, and I believe after speaking with a few different people.
That's my understanding as well, Your Honor. She was here, I know she got out of the, she was in the hospital for about 2 months. She was here on the walker. I don't know what happened, that she didn't let me know what happened, so I apologize.
Any ideas whether she's going to be going into QRT or?
No, she's not able to go to QRT. I know Megan spoke to her, but she was not eligible.
All right, well, given that she was here, I'd be inclined, unless the state has a compelling reason otherwise, to grant a continuance.
We're okay with that.
All right, when would you want to come back, Mr. Holt?
I don't care.
Can we do the 31st, would that be enough? Is it too long? That's next time here.
31st would be fine.
Thank you, Your Honor.
All right, we'll reset this to 10:31 for preliminary hearing. If she's talked to QRT and the like, I can see her thinking that the case was done for the day. And
She's been very cooperative the entire time.
yeah, I don't have anything here that indicates that she has failed to appear or anything on the file, so we don't have an issue with her continuance circumstances. All right, well, court will take a quick brief recess then to let everybody catch up. And maybe after Ms. White gets off the phone with the victim, maybe some movement in this as well. So I'll do a brief recess.
Oh, you're still? No, I haven't.
So,
Jackson's right here.
okay, so there was a witness who saw this stuff.
Yeah.
And she took a gun. And I think the
Go see
circumstances
Mr. Major.
of being there were kind
Go talk to Mr. Major. Who's that? The guy that we just talked to out there. Go to the office on the left-hand side of the building.
Victims that I spent the night with my girlfriend. And then statement, he says that she came over at 3:30 a.m. in the morning, that he left at 7:30 a.m. There probably will be these licenses.
Yes.
Kind of wondering why she was there.
Yeah, it's possible. I think it needs to go to the grand jury, and maybe nobody will show up to testify.
That just means it's not.
I can nominate to the grand jury.
You'll get her here.
Is she here?
No.
But I had it scheduled as she did, I'll talk to her.
Why didn't they have These two, do they live in it? So she still has this in here?
No.
Okay.
So,
Did they just wear one of them was on the phone with some guy? This one. His son.